Marijuana cases are becoming extremely common in the OWI world here in Wisconsin. We're one of the only states, frankly, where an individual doesn't have to actually be under the influence of marijuana in order to be prosecuted for it. An individual just has to have what's considered to be a measurable amount of the delta-9 metabolite that's in marijuana in their blood. And what's interesting is that the legislature in Wisconsin has essentially given the laboratories free range to determine what that level of detection is. And the level of detection is 1.0 nanograms per milliliter. To put it in perspective, it's less than a billionth of a grain of sand. And moreover, there is not a single scientific peer-reviewed study in the country that would lend one to believe that an individual could be impaired or under the influence of marijuana to the effect that it would have some sort of cause a problem with their driving or render them unsafe to drive. However, in Wisconsin, if it's in your blood, you can be prosecuted for it. And we're really seeing an upswing despite a country where a lot of other states are putting in different types of laws as marijuana becomes more legal across the country. They're putting in higher levels of detection, meaning different higher levels and limits like 5 nanograms per milliliter in certain states, levels that would be more in line with the level that someone's getting to become impaired. Wisconsin just doesn't care about that. And what's really scary is that there's no difference in the way that these cases are prosecuted from a penalty standpoint. The offense of operating with a restricted controlled substance of marijuana, or frankly any drug, the penalty exposure is identical to someone who's been prosecuted for operating with a prohibited alcohol concentration, even if that alcohol concentration is a really high number. So it's extremely important that if you have been arrested for and are being charged with any type of offense, be it a first offense, second offense, third offense, or higher, for drugs where they're alleging controlled substance or restricted controlled substance, that you have a lawyer that really understands the mechanics of scientific defenses that might exist within the framework of your case.